All right, so why should I give him 5 years? The complainant in this case is the same complainant that he has the new case on.
There was some other things going on in his home life and stuff. I believe he's had some family health issues and stuff.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years. All right, the court is going to sentence you.
This guy walked into court acting like 5 years was a fair deal for what he did, like it would wrap everything up and he could move on. But what he conveniently left out is that this wasn't even his only assault case. He's got another assault charge involving the exact same victim, yet somehow he thought both cases would just roll together like some kind of buy one get one deal in the criminal justice system. Once Judge Boyd started digging into the details, you could immediately feel the tone in the room shift. This wasn't just a one-time mistake, or someone having a terrible day. It was starting to look like a clear pattern of violence that it's honestly hard to understand how someone can nearly destroy the life of the person they claim to love, not once, but twice, and still walk into court with that much confidence. Let me know in the comments. Do you think 5 years is ever enough for repeat violence like this, or should someone like this be facing the absolute maximum? Let's dive in.
Calling 2025 CR 01152. Could I have parties announced?
Your Honor, there's also the MTR.
Yeah, I'm going to take this up first.
Can we do the MTR first?
Why are we doing the MTR first?
Uh,
And are you Mr. Gary?
Yes, ma'am.
Counsel, you received all discovery.
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. By entering into a plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, freedom of information, and rights under Article 1.051. By information, you're charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. Did you understand that to be the plea?
Yes, ma'am.
State?
there is, with the exception of, I had put restitution, should there be any, I know that he would be entitled to restitution here.
All right, it's gonna be restitution if any. Let me just tell you, if they're sending you to prison and your counsel is waiving a PSI, then whatever that restitution amount that person claims, that's gonna be the restitution amount. And when you're up for parole, they'll take it up with parole. Do you understand?
Yes, ma'am.
All right, restitution, if any, to Anessa Nicole Guerra. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. At this time, state orders into evidence, states Exhibit 1 with all attachments.
No objection, Your Honor.
Court will accept into evidence states Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, it was kind of a tough decision for Mr. Geary to come to, but he thinks it's in his best interest, and he would ask the court to go along with the plea bargain that it's taken us quite some time to negotiate. But I think he wants to get this behind him. It's unfortunate that we've ended up here, but I think he is ready to move on and become a productive citizen once he gets this behind him.
All right, the court is going to sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Anessa Nicole Guerra. There's a $1,500 fine. State is taking in consideration 2025 AL 006681, 2025 PF 31338, and this will run concurrent with 2020 CR 12202. And there's to be no unsupervised contact with minors. Is there anything else with regards to sentencing?
No, Your Honor.
Just that whenever we're finished with this and the MTR, we have the victim present who wishes to do victim impact statement.
Okay. All right, we're proceeding with 2020 CR 12202. Are you the same Juan Carlos Aguirre Jr., who was placed on deferred adjudication in 2020 CR 12202
Yes.
for the offense of assault, family choking, strangulation on March 3rd, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number 15. On or about the 12th day of May 2021 in Bexar County, Texas, the defendant, Juan Carlos Aguirre Jr., did then and there fail to attend.
This part honestly blows my mind because we're talking about a second assault on the same victim. Yet the discussion somehow turns into whether the next 5 years should just run at the same time as the first sentence. That just doesn't make much sense to me, that if someone is already on probation for putting a person in the hospital and then goes right back and does it again to the same victim, why would that ever be treated like it's all one big case? Situations like this are usually when the system decides to come down hard, because it shows the first sentence didn't change anything. What makes it even worse is that cases like this can make real victims feel completely hopeless. This guy already had an opportunity to straighten his life out, and instead he went right back to the same violent behavior. That if there's ever a situation where consecutive sentences actually make sense, it's something like this. What do you think? Does concurrent time make any sense at all for repeat violence like this?
Comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program, in violation of condition number 15.
How do you plead to that? True or not true?
I don't know about you guys, but 8 years honestly feels a little light when you really think about what this guy put someone through. Twice. Still, seeing Judge Boyd go beyond the original plea deal at least shows the court wasn't willing to treat this like a one-time mistake. It's a reminder that when violence turns into a pattern, the justice system eventually stops giving second chances and soft landings. More than anything, I just hope the victim can finally have some distance and peace after all of this, because no one deserves to live in fear, especially from someone who keeps proving they can't control themselves. And while 3 extra years might not sound like a lot to some people in the comments, that's a long time when you're sitting in a cell thinking about the choices that got you there. Considering the maximum sentence in this case was 10 years, I'm curious what you think. Was 8 years enough, or should the judge have gone all the way to the full 10? Thanks so much for watching. Don't forget to like and subscribe, and feel free to share your thoughts in the comments. Your feedback really helps me improve these videos, and I appreciate every single one of you.